let's talk about proprietary estoppel. If you wish to enforce a promise made in relation to land or property, then you might be able to do so via a proprietary estoppel claim. In order to bring a successful proprietary estoppel claim, 3 key elements must be present. A promise made to the claimant by words or conduct, which led to the claimant expecting that he would become entitled to a right or interest in the defendant's land. Reliance by the claimant on that promise, and detriment suffered by the claimant as a result of that reliance. If these 3 key elements can be established, then it is necessary to identify whether it would be unreasonable for the person who made the promise, or his estate, in the case of his death, to go back on that promise. Case law has established that the promise must be clear enough, a statement of intention is not sufficient, the detriment suffered does not have to be the expenditure of money or some other quantifiable financial detriment, as long as it can be shown to be substantial. There must be a clear link between the promise relied on and the detriment. The context of a promise is also important, and evidence of a promise is absolutely key. Many of these cases turn on the strength of documentary and witness evidence. Proprietary estoppel can allow the court to step in and stop the person from going back on their promise if the circumstances are such that it would be unreasonable for a person to fail to uphold their end of a bargain. When it comes to a successful claim, the courts have a very wide scope as to what award to make to a successful claimant. This could include the grant of land or a sum of money in compensation. Proprietary estoppel claims often arise in relation to farming family contexts. For example, a farmer may have promised his son that he will give him the family farm, and relying on that promise, the son works on the family farm for many years on a low, below market wage, giving up the opportunity of better paid employment elsewhere. The farmer then dies and fails to leave the farm to his son, who could then have a proprietary estoppel claim against his father's estate. Over the past few years, a significant number of proprietary estoppel claims involving farming families have ended up at trial. Proprietary estoppel could be renamed the law of farms. Nearly all of the reported cases involve farming families where promises have been made. "One day, this will all be your son," is a phrase we hear all too often. There are many reasons for this, including the dramatic increase in agricultural land values over the past few years, which leaves far more for family members to fight over. There continues to be a reluctance within some farming families to think about succession planning, and the multi-generational nature of many family farms and the increasing number of farming families where the next generation are moving away from agriculture often poses further challenges. The fact that many farming estates often have significant assets but little in the way of cash that can be used to settle disputes also frequently makes settlement difficult. The increase in society as a whole of second and third families has also led to increasingly complex family relationships and the increased likelihood of disputes arising. To minimise the risk of a proprietary estoppel claim, try and avoid making promises or creating expectations in circumstances where you do not intend to fulfil your side of a bargain. This includes promising to leave property to someone on your death but then failing to do so. In order to protect an estate from a proprietary estoppel claim, it is important that owners of assets consider their succession planning at an early stage. Where possible, it is best to include all family members with any expectation of benefiting from the estate in that decision-making process, and to make sure that decisions are taken openly. Making a will which clearly addresses succession and a letter of wishes which explains the thinking behind that succession can also offer protection. A failure to take a considered approach may well result in costly litigation and a breakup of family relationships and family assets.